All right, morning everyone. Welcome to the St. Patrick's Day version of the Judiciary Committee. My name is Carl Rhodes. I'm chair of the committee. Everybody's here today. We have just one agenda today. It's at 9:35. As noted, this hearing is being, oh, it hasn't been noted. This hearing is being streamed live on YouTube. You can find links to viewing options for all Senate hearings and meetings on the live and on-demand video page of the legislature's website. If you're interested in seeing the written testimony, you can go to the legislature's website as well, which is capital.hawaii.gov. If we have a catastrophic technical failure, we will pick up again tomorrow at March 18 at 9:25 in this room and on video conference, and we'll put up a notice as well. For the people who will be testifying remotely, you'll be muted and video disabled until it's your turn to go. And we do have a 2-minute time limit on oral testimony. If there are temporary glitches while you are testifying remotely, we may have to move on to somebody else, but we'll try to come back and fix the glitch. If not, we have your written testimony. Okay, I think that's it for the preliminaries. First up on our agenda today is HB 124, which requires the chief elections officer to develop and distribute a voter information guide for all candidates running for state office, including OHA. First up on 124 is Scott Nago, Chief Election Officer. Good morning.
Good morning. The Office of Elections will stand on its written testimony providing comments and be happy to answer any questions.
Okay, thank you. Next is Sandy Ma, Executive Director for Common Cause Hawaii. Good morning.
Good morning, Chair, Vice Chair, and members of the committee. Sandy Ma for Common Cause Hawaii. Thank you for allowing Common Cause to testify remotely on HB 124. We do support this measure. We think this is necessary for an informed electorate. We understand that the State Office of Elections is requesting that candidates be able to provide their own information for a voter information guide, and has provided cost estimates for supplying a voter information guide to the public. We suggest that for a truly informed voter information guide that's trusted and useful to the public, that it must be neutral and written in a plain language. And we also suggest that this committee take a look at California and Alaska's voter information guide, which provides that if the candidate is asked to provide their own information to supply to a voter information guide, that the candidate should pay for such placement in a voter information guide. So that is my additional testimony that is in supplement to my written testimony. Thank you very much for allowing Common Cause to testify in support of HB 124, and I'm available for any questions. Thank you.
Thank you very much. Next up is Janet Mason for Legal Women Voters. Good morning.
Good morning, Chair, Vice Chair, members of the committee. I'm Janet Mason. I'm testifying in strong support of this bill. We like the bill very much, but since the intent is similar to SB 2210 SD2, we hope you'll take some of the language from the Senate bill and put it into this bill. In particular, the guide obviously needs to specify what the contents are. And we like what is contained in Senate Bill 2210, the explanation of the ballot questions, statements from each of the candidates, and the process in the Senate bill for resolving the pro and con arguments on the ballot questions is very good. We hope that's included. The candidates should prepare their own statements. We think that that adds some value to understanding what the candidate is like. It's all somewhat cost effective. And perhaps I think I suggested previously that it would be helpful if the Office of Elections provided a template for things like their content, their contact information, and why they want to run for office and so forth. We hope that you will add a requirement that the voter guide include a link to the Campaign Spending Commission website so that voters can find out who the main supporters of the candidate are and also find out whether the candidate has, the non-candidate committee has complied with the spending limits for the election. We like the effective date. We would like the effective date of the bill to be January 1st of 2023 in time for the 2024 elections. And we're just delighted that the legislature is seriously considering doing this. It's something that the league has
Thank you very much. Your
promoted for years.
time is expired.
Thank you.
Thank you. Next is Craig Garai, Director of the Department of Budget and Finance, with comments. Kat Brady for Community Alliance on Prisons. Support. That's all the testimony we have on HB 124 members. Any questions? Senator Gabbard.
Office of Election.
Yes.
Yes, when would the voter guide be mailed out? Do you have a
So
date?
if it's for the, are we talking about for the 2024 election or?
Yes.
Okay, so it would be after the close of candidate filing, we would compile all the information. We would make it available, but not necessarily mailed out 45 days prior to the election because of the Okava voters. And then we would try and mail it out as close to as ballots going out as possible. If it's mailed out. So the way the bill is written is it can be mailed out or it can be made available online.
All right. Thank you, Chair.
Thank you, members. Any other questions? I guess not. I don't have any either, so let's go ahead and move on to the next bill. Thank you very much, Mr. Nago, for being here and the other testifiers. Next up, we have HB 1539 relating to the safety of judiciary personnel, prohibits the posting of judges and other court staff's personal information on the internet with the intent to intimidate or threaten. First up, we have Susan Payne-Gotros for the staff attorney for the judiciary.
Good morning.
Good morning.
Thank you. I'm discussing House Bill 1539, which is part of the Judiciary's administrative package bill. Last year, federal judges were the target of more than 4,500 threats and other inappropriate communications. Such actions against our own state judges and judicial officers have escalated in both number and severity in recent years. And our testimony discusses some of the recent security issues judiciary officers and judges have faced. For instance, in Illinois, a disgruntled litigant shot at husband of a judge and her son, killed her son in their home after finding the judge's home address on the internet. House Bill 1539 helps protect judges and specified judicial officers. It has three components. First, it prohibits people who have an intent to intimidate or threaten from posting on the internet any personal information of state or federal judges and other specified judiciary staff. And second, it provides steps for removing that information from the internet. And finally, and probably most importantly, it establishes a task force so that government offices and other entities can collaborate on recommending legislative action to further protect judges. Federal judges Clifton and Seabright have testified that judicial security is critical to our democracy and the rule of law, and judges must make decisions without fear of intimidation or harm to themselves or their families. This bill is an important first step in ensuring that they may do so. Thank you, and I'm happy to answer any questions.
Okay, thank you. Next is Gerard Silva in opposition. Shannon Sheldon, President of White Bar Association, in support. That's all the testimony we have on HB 1539. Members, questions? Senator Kim.
For the judiciary. Can the judiciary create a task force now without this bill?
Yeah, I suppose it could, but I think it would be helpful to have a bill that provides the reasons for doing so and the participants and the task force and the next steps it would take in determining what kind of further legislation might be appropriate.
Yeah, but we are two separate branches, and so as a separate branch, judiciary can in fact be proactive and create this task force and not wait for the legislature, right?
That's right.
So important. Thank you.
Members, any other questions?
Sure.
Senator Favela.
I kind of understand about the safety, but you know, in all the line of work that we all do, public servants, yeah, we're going to start putting a group of people in a different area, in a different level of what can be and can be assimilated through, personal information. When we live on one island, having a bill like this to protect the judges and all, which is great, but are they protected already federally as judges?
Well, this bill is actually doing something that that other states are starting to do, and actually federal government is actually looking for legislation, and that is to make sure that information is not just put on the internet with an intent to threaten or intimidate a judge. So that information, for instance, in the Illinois situation, that information wouldn't be there, so that the disgruntled litigant could go to the House and take action against the judge. So it's a little different than the regular legislation that discusses harassment and that kind of thing.
Yeah, I got a question. So is any of the judges and people that work for the judges, is that for like public? Is it public office?
Sure.
So then that's why I'm not understanding that we're gonna do this. And if anybody that wants to go after anybody for intimidation or whatever level it is, it won't be hard to find them on an island, especially in Hawaii. But we're gonna put this in, and then next legislation, all of the senators over here want a bill to protect their privacy and their home and their address, their email, and anything that's said about any of us here going forward to intimidate us on how to vote and not to vote. Then how democracy is gonna go forward. I understand. So these judges that came up to judges, they've been judges for a long time. So they knew when they got into this field, there will be some kind of risk of their information or even intimidation and briberies and all of this other stuff that come forward in being in the position. Same like elected officials. We have the same thing that can go on with us going forward. I just have a hard time putting this together, because if we do this for this group, the judges and their staff, then another group of people, correction officers gonna wanna do the same thing. Then the police department gonna wanna do the same thing. Then how are we gonna be able to enforce these laws? Senator Kim already said, you guys have you guys own judicial powers to do this task force without this bill.
Well, the task force is just one component of the bill. The other aspect is the privacy about the home addresses and personal information on the internet. And I can't tell you, I've talked to judges who feel terrified when people come to their house and, to serve them with documents or to voice their concern about rulings that they've made, and they don't want their home addresses to be that available. So it's limited in that respect, and it's very limited in its scope. And we felt like it would be presumptuous to put other entities or other offices within the bill, but there may be a need for that as well. And other states are taking that kind of action and coming up with legislation that's similar to this.
Thank you, Chair.
Thank you. Anyone else with questions? I do have a question for you, Ms. Gotros. I was just curious, it doesn't appear that per diem judges are covered. It's just full-time judges?
Right, and that came up before, but we at this point, we just put down full-time judges.
What was the reasoning for that?
I think the reasoning is per diem judges have other aspects of, they're not only doing judge work. I mean, they're also doing litigation on their own. They may have other offices or other positions besides being a per diem judge.
Okay, so basically the argument, I guess, is that as a practicing attorney, you want people to be able to find you.
We're not opposed to changing it, and that did come up in another committee. So we would not be opposed to changing it to per diem judges as well.
Okay, all right, thank you. Other questions, members? If not, thank you, witnesses, for being here. Appreciate it. We'll move on to the next bill, HB 1828. This beginning in the 1st of January 2023 would amend the membership composition, compensation, and duties of the Taxation Board of Review. First up for 1828 is Director Choi. Good morning.
Good morning.
Of the Department of Taxation. I'm assuming that everybody knows your Department of taxation, but
I
probably
try
not
to- I
everybody
try to
does.
keep incognito as much as possible. Chair, Vice Chair, thank you. Committee members, thank you very much for this opportunity to testify. You know, it could be time for this particular paid board to come to fruition. As you know, we are having one hell of a time.
Sorry, could you hold the mic up a little closer? I can hear, but I'm not sure if people who are listening here. Thank you.
We should be able to take our face bill. Well, anyway, you know, we're having one hell of a time getting volunteers to volunteer for this work, only because the tax issues are getting more complex and the taxpayers are getting a lot more creative. And to really give process to the taxpayers, we're gonna have to start doing a lot more research, right, on their particular point of view on how taxes should be administered or how laws should be interpreted. So this particular paid border review would not only help taxpayers, but it would also cut back on the big backlog that we have. And both the tax appeals court and the border review have hundreds in their inventory, right? But it's not the hundreds that I'm concerned about. It's more the time frame. Some of those cases are 10 years old, and we need to get these things moved. So we fully support this bill and we stand on our written testimony. Thank you, Chair.
Thank you very much. Next up is Tom Yamachika, Tax Foundation President, Tax Foundation of Hawaii President. Good morning.
Good morning, Chair, members. Tom Yamachika will stand on a written testimony and be available for questions.
Thank you very much. Next is Craig Harai, Director, Department of Budget and Finance, with comments. And that's all the testimony we have on HB 1828. Members, questions?
Yeah,
Senator King,
questions.
go ahead.
The Director of Taxation, who's trying to be incognito.
Whose home address? I'm just kidding.
I need to be protected.
Yeah, you probably do. How much is this gonna cost us?
I think the bill says $500,000.
I thought it was blank. I didn't see that.
518, 452.
And that is for the
The three board members plus I think two staff. members.
and this is at what kind of salary?
It's also stated in here. I think the chair gets 85% of director's
Right,
salary
so
and then it goes down.
So that would be approximately for a board member. What is that approximately?
120.
And that would be a full-time position.
Yes.
So do you have just one tax board now or two?
I'm sorry.
Just one, you just have this one tax board review?
Yeah, but right now I've consolidated the tax review boards to have one. There's another bill going on to make our corrections, but what I really wanted was a pool of volunteers so we can have both 3-member boards. That hasn't come to fruition yet, but again, it's.
So I guess I'm getting confused with the property tax because they have
Yeah.
they have a couple of different review boards, but yeah, just a
So
one.
this will be only one. Yeah.
And this board has been in existence for how long?
Well, no, this one is brand new. This paid board is brand new.
No, your current
Oh.
board, I'm sorry.
Ever since I was a practitioner, the board of review, I've practiced before that.
And they meet how often?
Oh, as the cases come up, they do schedule as many as they can.
But you said that you have cases that have been lingering, so when you say they meet when it comes up.
Yeah, so some of the cases are extended. Some of the issues, for example, constitutional issues, they're just gonna have to waive it because they're not gonna take those cases on. Sometimes the taxpayer wants more time. No, when you have a formal board like this, we can set deadlines. So right now, like I'm doing 237D4 by myself. And I set deadlines and I said, hey, you gotta come here at this time. This is your discovery cutoff. This is your pre-hearing date. This is and we can set everything up very, very formally. On a volunteer board, it's very, very difficult because you're gonna have to manage everybody's working. Everybody has a job and you're volunteering for this board. So, it's very, very difficult to schedule.
So at this rate, what kind of people you think would give up a full-time job that they're doing to be on this board?
Very good question. I personally, if I was in practice, I probably wouldn't want to apply for this particular job because I would make a lot more in my
Exactly.
practice than I would on a board like this.
Yeah, so what kind of quality are we gonna have with people being employed and then serving on this board?
Well, again, to be honest, I think you're gonna get an older gentleman or lady, probably be at the end of their practice life, probably around 55. I think they'll be excellent because they'll have this practice experience and then they could finish their careers in public service.
Thank you.
Thank you. Members, any other questions? Okay, I think we're ready to move on to the next bill, which is HB 1841. This increases the rate of compensation and maximum allowable amounts per case for court-appointed counsel and guardian ad litem, or guardians ad litem. Sorry. 1841, our first up, we have Matthew Viola, Senior Judge for the Judiciary. In support, Marilyn Yamamoto. In support, Milani Fujimura Kaina, Executive Director for the Legal Aid Society of Hawaii. In support, I'm sorry, Marilyn Yamamoto is testifying for Hawaii Family Advocacy Team. And we also have Shannon S. Sheldon present for the Hawaii State Bar Association, also in support. That's all the written, or that's all the testimony we have, and no one to ask questions of, so we'll go ahead and move on to the next bill, which is HB 2365, creates an electronic citation program under the Judiciary and establishes an electronic citation surcharge. First up on 2365 is Kevin Portman for the Judiciary. Great, thank you. Next is Jay Butai, Director, Department of Transportation. In support, Andre
Aye.
Peter. I'm sorry, you here, Director? Oh,
Mr. Chairman,
Deputy Director.
Chair
Okay.
Rhodes. Aye.
Morning.
Chair Rhodes, Vice Chair Kalole, and honorable members of the Judiciary Committee. The Department of Transportation is in support of the measure, and we would like to stand on a written testimony. Thank you, sir.
Thank you. Next is Andre Peters, Captain Traffic Division for Honolulu Police Department. In support, Craig Harai, Director, Department of Budget and Finance with comments. Paul Ferreira, Police Chief for Hawaii County Police Department, also in support. Gerald Silva in opposition. Those are the testifiers we have for HB 2365. Members, questions?
Oh, I have a quick question, and
Sure. Senator,
maybe it's in the bill and I probably didn't read it that well. So I know the number of testimony says it'll take less time for police to stand on the corner and issue a citation.
Sure.
So,
Who are you asking?
I don't know. I guess transportation, the court or transportation, they both said that in their testimony. Or
Mr.
is
Thornton.
there anybody from the police here?
Mr. Thornton, you want to come up?
Oh,
Judiciary, is that?
okay,
who you're
that's
after?
fine.
Okay.
Yeah. So
Good morning, Chair.
they
Vice
would
Chair.
be saving time only because they would be able to, they would have some portable electronic thing that gives a citation, or
So they would be using smartphone, which can scan barcodes. So licenses, motor vehicle registration, anything that's has a barcode on, that's an instantaneous capture of data. It saves all that time writing. It eliminates handwritten.
okay,
you
but
know,
they
and the
still
errors.
have to be there physically and.
Correct.
get the-
Yes, but
okay.
it should reduce the time.
Okay, I
You
just
know,
want
the
to make sure
technology
that
should
they
help
were
that.
still, it wasn't that they saw a car into the red light and just did an electronic. one. Okay, thank you, that's all.
Members, any other questions?
I have a question.
Senator Favela, go ahead.
So now they're gonna be scanning the ID documents. So it's just a barcode that they're gonna scan, or the ID and everything, and everything about the car is gonna be stored into a database?
It's at the moment, they just scan the barcode. They can take pictures if there's anything wrong with the barcode. Occasionally, they do have instances where the barcode fails, in which case they want to take pictures. That's the other value of the program. You know, they can use their smartphone to take pictures of the scene and any documents.
So the barcode that they're gonna have, it doesn't have any pictures or anything like that, that they're gonna be storing any information that could end up in other people's possession.
I would think there is a potential that pictures could be captured in the database. The database is secure. In choosing the vendor, we did make sure we checked all the boxes in regards to security. The system is, meets all the security standards. I can read them if you wish. And one of the customers is the United States Air Force. So and they have many other customers as well. So they do secure the data. The data is in, there's all the different things that we look for, including, other databases located in the United States, what's their policies in regards to securing the data, in regards to background checks for their staff. So the data is secure. Yeah, but again, we are capturing, I would think, PII.
So is the vendor local or is it from the mainland?
This vendor is from the mainland. We do not have any local developers that produce this type of product. So this particular vendor that we chose has over 100 different customers at this time. So it's cheaper to go with what we would call a commercial off-the-shelf product, and rather than development costs, hundreds of thousands to millions of dollars testing, and then including the very important fact of security, that takes a long time to get that certification. This vendor's in place, has been in place for many times, has many years, has hundreds of customers. So that's why we went with this vendor for this particular pilot. But then if this program was to go forward, obviously we would use the procurement system to choose a vendor, through the appropriate procurement processes.
So is there more than one vendor that does this kind of technology?
30 that I saw on the site that do different variations, including the red light cameras. So red light camera is basically another e-citation. It basically collects data, transmits it.
Well, the only reason why I'm bringing this up is that we always outsource everything that we do here, from safety checks to writing to our Department of Health, paying bills, everything is outsourced. So I just wanted to know when we're going to start. When we think about this kind of technology in the future, when are we going to start bringing tech companies and this kind of technology here to our island so that we can get people that have these kind of tech jobs and companies and giving our local people jobs instead of they go to the mainland and learn how to do this and live in the mainland instead of living here.
Yeah.
This is like about the third different tech company I know that we're outsourcing everything to the mainland. I started with safety check. A lot of the safety checks are done here locally. You take a picture, goes to the mainland in California, then they send back the information if there's any changes or whatnot. But the vendor, the program, the printer, everything is all done from a mainland company. I just wanted to make sure that we don't get locked into a program that only get one vendor. And then when this pilot program go full force, the state of Hawaii and the taxpayer is going to have a hefty cost of running this program.
I said there are multiple vendors, so it would be a competitive procurement. This particular vendor did say they were willing to relocate staff to Hawaii to support the system. And that could be a potential for some of these vendors. I do agree with you, Senator. We do need to grow our local IT tech capability. There are companies locally, but unfortunately none of them got into this area. So, and it's it's a huge uplift. You have to invest huge amounts of money to develop and then ongoing. So I'm not sure they would be willing to engage at this point in this particular area. But
Thank you, Chair. Thank you for that. Appreciate it.
Senator Kim, go ahead.
Just real quick follow-up. So right now, can they do scan your barcode and everything
Yes.
without a lock? They can, right?
This program's been running since 2017. The system is
Okay,
active.
so the only thing is that you need the charges, you need because everything in the bill talks about the citation surcharge.
The system needs funding, whether the special fund is appropriate. We did just see the auditor's report that I believe said no to the special fund. So anything the legislature can do in regards to recommending how to fund this, we would greatly appreciate that. It is a cross-agency program. We're dealing with the judiciary, the executive branch, the counties, prosecutors, all the police departments.
Right, but it's basically they can do the scanning and they can do electronic, they just remove the surcharge and the cost.
To permanently fund the program, because
Okay.
yes, at the moment it's just funded through
Thank you.
NHTSA, the National Highways Transport Safety Administration,
Thank you,
and that's a pilot.
thank you.
Thank you.
Members, any other questions? I do have.
One more follow-up. Sorry,
Oh,
Chair.
go ahead.
Since you said the pilot program and transportation, is any of that funding that doing this pilot program because it's doing with transportation, will have anything to do with any kind of federal funds?
It is federal funds. It's the
Or
national.
it is gonna be
fund.
federal
Yes,
funded?
It's coordinates and national.
Oh, right
highway.
now,
Right now.
right now it's federally funded.
Oh, yes, correct.
Yes,
Yeah.
Okay.
yes.
And we're only funded for Honolulu and Maui. We can't expand to Hawaii County or Kauai County.
So I do have a couple follow-ups too. So thank you. So presumably, I mean, the argument for it is that it's more efficient, fewer mistakes, fewer human hours spent entering data in your whatever data system you're using now.
That's for the judiciary. I think the police departments have the viewpoint of road safety. So for the
Okay.
judiciary, it's definitely.
But it should save us. It should save the various government agencies involved money, correct?
That's correct.
How much, I mean, this is why I keep coming back to the surcharge. It's like, if we're saving money, why do we have to charge people more for getting a ticket for, that they would have gotten otherwise anyway?
Yeah. Well,
So, I mean, you sort of answered it already in terms of you don't really care where the money comes from, but there has to be some.
Yeah. As I said, I've already turned to the legislature to fund this program or look at ways to fund it. At the moment, on January 27th, we provided the amount of money that was collected through citations. I think it's around about $30 million that we provide to state treasuries. I don't know how it's divided up after that. So that is another option if you wish to look at those funds and just divert part of the fine that's already collected to pay for this.
Okay.
It's again, the people on this committee are not really money people, they're lame people.
How big was the NHTSA grant?
I'm sorry, I don't have the numbers right in front of me. The program cost is estimated at 1 million. I believe we're about at 1/5 of that at the moment. In regards to, so I
A
would
couple
say
$100,000 probably.
correct.
Okay. Then also getting back to Senator Favella's question about security. Now, there is a database already, right? It's just that the way the information is entered is different, and maybe it doesn't have pictures. I mean, they're manually entering all this stuff, right?
At the moment, so the vendor has a database that's in the cloud. That's used by them.
Oh, I meant for the. I'm sorry, I know it's not clear. So before the pilot project got going, for the counties that don't have the pilot project, they're still entering something in a database, correct?
They enter data into their record management system. They send us the citation. We scan the citation. We data enter the citation. We correct the citation based on errors on the citation.
So there's still a security risk of some kind with that database, just like there would be with this database.
The judiciary's database, we go through the same security checks, and I
Right.
assume the police departments also secure their data.
Okay, thank you very much. Thanks for being here.
Thank you.
Members, any other questions? Okay, let's go and move on to the next bill, which is HB 2421. Establishes a 3-year women's court pilot project program within the judiciary's first circuit, which is Oahu. First up is Brooke Mamizuka for judiciary. Sorry, looking in the wrong place. Ms. Mamizuka, are you there? There we go. Good morning.
Good morning, Chair Rhodes and Vice Chair Ke'oka Lole. I am Brooke Mamizuka, Probation Administrator. The Judiciary supports House Bill 2421, House Draft 1, to create a women's court pilot program. The Judiciary appreciates the legislature recognizing women entering the criminal justice system in different pathways that are different from men, and that the current tools and policies are not effective at keeping justice-involved women out of jail and prison. We're looking at ways to break the cycle of re-entering the criminal justice system. Research is showing us that women enter the justice system in different pathways from men: poverty, victimization, mental health issues, substance abuse disorders, trauma in forms of physical and sexual abuse, and unhealthy relationships. When these issues are not addressed, it creates a cycle of suffering for themselves and their families. The goal of the Women's Court program is to address these issues rather than sending women back to jail for nonviolent crimes. The program will be based on a probation model that will, with the core objectives of collaborating casework and including services in mental health and substance abuse. The program establishes a 3-year program, and the judiciary is requesting an appropriation in the amount of $695,236 for fiscal year 2022 and 2023 for equipment, contracted services for mental health, substance abuse, and other services that establish staff and positions for the Women's Court Pilot Program. Thank you for the opportunity to testify in the matter. I'm available for any questions.
Thank you very much. Next is Trisha Nakamatsu for the prosecutors for the City and County of Honolulu. Am I on the wrong one? 2421, Women's Court?
Oh, I'm sorry, Chair. The record was done on this one.
Okay,
Thank you.
thanks. Next we have Craig Harai, Director, Department of Budget and Finance with comments, Department of Human Services and support. Shannon Sheldon, President of Hawaii State Bar Association, support. Mihoko Ito for Hawaii Women's Lawyers and support, and Dara Carline support. That's all the testimony we have on HB 2421. Members, any questions?
Question.
Senator Kim.
Yes, so from Ms. Mamazuka, doesn't the judiciary have the ability to create special courts on its own?
Right now, this court is a little bit different, Senator. We're used to more kind of neutral gender specific types of services, and our tools and our assessments are all geared more towards general neutral. This one would be a little bit different. Where
my question is, do you have the ability to do special courts?
We do have special courts.
You do, so you can do this. Now you're asking for funding, and that's why we have the bill. But technically, if you felt that this was important, you could in fact use money from your own budget, and you could create this court.
I'm not sure if we would have money to.
No, the judiciary has a budget. And you,
yes,
you currently try women now, and you currently have programs that you might, a judge may decide to have a woman go through. So you do that currently. And so you can at this point do a specialty court if you wanted to. That's my point. You can do that, right? And you can come in and ask for additional funding.
We can do a court,
okay,
but probably not to the same standard that we're looking at.
Thank you.
Members, any other questions? Okay, thank you very much, Ms. Mamazuka, for coming in, and Ms. Nakamatsu. Let's go ahead and move on to HB 1427. This is related to reports filed with the Campaign Spending Commission. Clarifies that candidates are not required to file preliminary general reports if they're either unsuccessful or are elected in the primary. First up on 1427 is Gary Camp for the Campaign Spending Commission. Good morning.
Good morning, Chair, Vice Chair, members of the committee. The commission has submitted testimony in support, and I will stand on that written testimony. Thank you.
Thank you. That's all the testimony we have on HB 1427. Members, any questions? Okay, let's go ahead and move on. Thank you, Mr. Camp, for being here. We'll go ahead and move on to HB 1456 relating to theft in the second degree. It amends the offense of theft in the second degree to include theft of an electric gun. First up on 1456 is Alan Komogone for the Office of Public Defender.
Good morning, Chair, Vice Chair, the Office of the Public Defender. We submitted written testimony in opposition to this bill, and I'll rest on our written testimony and available for questions, if any. Thank you.
Thank you. Next is Jared Shiramoto, the Hawaii Police Department, in support. That's all the testimony we have on HB 1456. Members, any questions? Okay, seeing none, let's go and move.
I'm not sure if the, you have a question.
Go ahead, Senator Cossey.
It was, but I'm not sure if they can answer, but I was thinking if the police department was here, but if public defender is the only testifier, I'll just ask it. So, you know, with the differing costs, let's see. Are you aware if all electric guns You did note in your testimony that there are different costs. Do you know if the intensity or the effect that it has on a person is somewhat correlated to the cost, meaning a $20, you mentioned in the testimony, a $20 electric gun might have less effect than the one that was $1,599.
Yeah, I mean, I can't speak from personal experience, but I can only assume the law enforcement grade stun gun that costs $3,000 is going to be way more powerful than the $18 Walmart stun gun for sure. But I think just based on an internet search, it definitely looks that way to me.
Yeah. Okay, thank you. I yield. Thank you, Chair.
Thank you. Thanks for being here, Mr.
Thank you.
Komagona. Let's go move on to HB 1459. This relates to juvenile restitution requires victim restitution in certain juvenile cases. Clarifies the definition of victim for purposes of victim restitution in these cases. First up on 1459 is Andrew Park for the Judiciary. Good morning.
Hi, good morning, Chair Rhodes, Vice Chair Keoho Kalole, and honorable members of the committee. The Judiciary would stand on its written testimony in opposition to a portion of the bill, and which also made recommendation. I will be available for any questions.
Okay, thank you. Thanks for being here. And next is Starsha Forrester, Office of Public Defender.
Aloha, Chair Rhodes, Vice Chair Keoho Kalole, and members of the committee. The Office of the Public Defender did submit written testimony, but I wanted to emphasize a few things. We are in strong opposition to this measure. Juveniles should not be treated as if they are adults. We are deeply concerned that removing flexibility and walking away from providing options to restitution, thus saddling kids with debt, goes against the mission of the family courts and prioritizes money over the health, well-being, safety, and care of children in the juvenile justice system. We have provided some examples in our written testimony, and I would like to just remind this body that many of our children in the juvenile justice system live in poverty, live in foster care. They're often the children most in need of services, survivors of sexual abuse and exploitation, children without supportive or even present parents, children who may be homeless, and children suffering from ongoing mental health crises. Sometimes, not all of the time, but sometimes our family court judges need the flexibility to think beyond money, especially when there may be other options for compensation that go beyond debt, that will sometimes will keep children, and then what we call respondents, which is children who become 18, we call them respondents, tethering them to the juvenile justice system way beyond reaching the age of 18. There must be a place for restorative justice, community service, and prioritizing health and safety in our juvenile justice system when dealing with our most vulnerable youth. May we respectfully suggest the creation of a task force or a working group to look at the complicated issue of restitution, community service, and other services in our juvenile justice system as a means to do more of a deep dive into what is actually needed, what works, what doesn't, and what could be improved. Thank you very much for allowing me to testify. Mahalo.
Thank you. Next up is Trisha Nakamatsu for the Department of Prosecuting Attorney, City and County. Good morning.
Good morning. And good morning, Chair, Vice Chair, members of the committee, Deputy Prosecutor Trisha Nakamatsu on behalf of the Honolulu Prosecuting Attorney's Department. We are in strong support of this bill. It's part of our package, and we thank you for hearing it, Chair. Just to dive right in, we are not making any blanket statement or request that juveniles be treated as adults. And but that said, we would strongly disagree with any implication that restitution does not further rehabilitation. On the contrary, we strongly believe it does further rehabilitation for adult offenders, but also for juvenile offenders, law violators, as they're known in the system, and the legislature itself has expressly stated, and stated in our testimony, that they should develop or regain a degree of self-respect and pride in knowing that they've righted to as great a degree as possible the wrong that he or she has committed. Obviously, it is greatly for the benefit of the victim. Again, our testimony notes, not only financial, but emotional, psychological, social, everything that you can imagine that means something to somebody, to know that somebody truly cares enough about what they did to try to pay them back. And the way the courts order it is there's always an ability to pay component to these restitution orders, not in the amount that's owed, that's basically proven by receipts and then it's vetted through all the checks and balances in that sense. But the amount of the payments, the court's very understanding, family court perhaps more so than any other court, because they understand their role is the rehabilitation of the juveniles. If the juvenile has a part-time job, great, make your part-time payments, whatever, or make your payments, whatever you can do. You don't have a job right now, but you're going to school, you're trying, then payments will be skipped and that's fine. But, and then we also know that judiciary's testimony indicated that the chances of recovery are very low. We think that it would be zero basically in these cases that the court is ordering no restitution. Families are not required to pay the restitution, though the court still would have the opportunity to do that, and we're not asking that that be mandatory. While we understand OHA's concern about Native Hawaiian youth, we'd also point out that our stats kept by the victim witness Kokua services indicate that 30% of crime victims are also Native Hawaiian.
Thank you very much.
Thank you. Available for questions if any.
Thank you. Next is Pamela Ferguson-Bray, Executive Director for Crime Victim Compensation Commission and support, Maui Prosecutor's Office and support, Deanna Gausful-White for the County of Kauai Victim/Witness Program and support, Kapuna for the Mo'opuna in opposition, Amanda Chang for Berkeley Law Policy Advocacy Clinic Juvenile Law Center and the National Center for Youth Law in opposition, Office of Hawaiian Affairs in opposition, Chad Buck, CEO, Hawaii Food Service Alliance LLC in opposition, Nico Leverance for Hawaii Health and Harm Reduction Center in opposition, Kat Brady for Community Alliance and Prisons in opposition, Lauren Walker for Hawaii Friends of Restorative Justice in opposition, Trisha Paulette for Mothers Against Drunk Driving in support, Rebecca Villegas, Hawaii County Council Member in opposition, ACLU of Hawaii in opposition, Native Hawaiian Legal Corps in opposition, testimony for Melissa Tevis Pavlicek and Youth Action Hui in opposition. And then there's about close to 40 individuals in opposition and no one in support. Okay, members, questions?
I do.
Senator Kent, go ahead.
So currently, the judiciary, the judges can, it says they may, and you're striking may out to say shall. And in your experience, is that the judges just are not requiring it?
Yes. And actually, yes, frankly. And I'm sure there's lots of reasons why they may be doing that, but we believe also one of those reasons is that it's much easier to show sympathy towards the child, the law violator who's right in front of you, telling you about their difficulties, and perhaps not forget about, discount, give less weight to the plight of victims who, through no fault of their own most times, and they have no choice whether they get victimized by an adult or a juvenile, but now they're out of pocket for something that they were not expecting to have to pay for. And I think studies have shown, Star Advertiser showed us recently, that most families cannot even afford to pay a $400, something like that, a $400 unexpected expense. And yet these people have to go through it on their own. And at the same time, they've been victimized by a crime. And the fact that now it happens to be a juvenile, the courts don't necessarily order that restitution.
So is there a record to show that the judges absolutely, in almost all cases, do not do any restitution when it comes to a juvenile?
I don't think we actually keep stats. We can try to do a hand count of a number of cases. I wouldn't know. Perhaps the judiciary would have that information.
Okay.
I can try to look for it.
Okay, I share some of the concerns in that we're going to teach our young people that there's consequences, or that they're going into become an adult, and these are consequences that you're going to have to pay back. Yeah, and if there's areas in which the judges have that discretion in some cases, but I think the fact that we don't teach our young people that they grow up to be adults and continue to do the same thing and not expecting any kinds of consequences. So thank you.
Okay, members, other questions? Senator Favela.
So the restitution, So juvenile that does the crime and they're incarcerated, are they held into the restitution, or they're in a position that they're held for them to pay the restitution out?
When you mean they're incarcerated, like if they
Yeah,
go
they
to
got arrested for doing the
HYCF
crime,
or
and do they get
detention?
released before they get paid the restitution, or consider for restitution?
It's up to the court on how strict they would want to be while the child is in custody, but typically speaking, as I indicated before, the family court is perhaps the most understanding in my experience, and rightfully so. So they're gonna wait until the child comes out. Also, we note that there's a community service program that actually allows them to work off their restitution. So they do the community service, and then this program pays out their restitution.
No,
And
the
that's
reason why,
available as
I bring this up is, following up on what Senator Kim said, that about family courts, doing them or not doing them. The reason why I know that is because in my community, kids that vandalize the school, of course, the kid never hold responsibility, the guardian did. And it was assessed that the guardian pay the restitution. So I don't understand the part about they're not being responsible for their crimes or paying back the victim of the crime. I mean, we know that, juveniles do a lot of things, and we know they're gonna be held accountable for it. But unless we can change, even if we make this bill here, it's still gonna be the decision of the family court judge at the end on the restitution to give them one fine or reduce fine or community service, right? That's what, I mean, even if we pass this bill, is a recommendation, we'll put it to law and we'll tell the judge that they gotta do these things? Or is it gonna be a recommendation? So it's gonna be law that they gotta do these things?
Okay, just to make sure I'm understanding the question. So the judge, well, in family court, they typically, they most often don't order fines. They'll order community service, or order something perhaps a little bit more hands-on that the child can do, rather than just paying a fine. But restitution is different in that you have the victim who you're trying to make whole, and you're trying to show the child that you did something wrong that cost this person money, and they might not have time to, or, and that you have to pay them back. Family is not necessarily ordered, and this wouldn't change that. The family doesn't have to be ordered. And one of the big cases that comes to mind is when there was actually an adopted family who had been foster family and then adopted family. Kid got into a lot of trouble, so the court, we don't want the family to necessarily have to pay because they were good enough, and we don't want to discourage people from taking in troubled youth and whatnot. But yeah, we do feel that the child themselves, the law lawyer, should be responsible. And that would be mandatory if this were passed as it's currently written. But like Lumen indicated, they have a lot of time to pay it. The courts are very understanding, particularly family court. And there is this community service program that will help them to pay it off if they're willing to put in time, which they should be.
Yeah, thank you, Chair.
Thank you, Senator Casio.
Okay, Chair, thank you. So just to be clear, that the court discretion currently does allow for them to apply restitution to the juvenile.
It allows them to, but they just choose not to.
And the point that you made about that they could do community service, they can do community service right now in lieu of, or as a punishment, but it doesn't necessarily compensate the victims.
That's
The
correct.
community service.
And
But
actually, one of the changes, I'm so sorry.
Yeah. No.
But one of the changes, perhaps it seems minor, one of the changes that this bill would actually make would be to separate the restitution and community service language, I believe in subsection 9, to ensure that the court none of the judges would interpret that as either or. You either order community service or restitution, because we think they should order restitution, and then they can order community service if they like. And then what I think to your point is that if the child doesn't have a part-time job, but they're able to do community service, then there's this other program that allows them to do community service through this special program, and then that pays the restitution. Whether the court on top of that requires the child to do community service as part of their punishment or what have you, that would be up to the court still.
Okay, thank you, Chair.
Thank you. Yes, Senator Keokalole, go ahead.
So, my read of the judiciary's testimony is that the concept of restitution is flawed on its face. And so I guess I'm wondering what the objective is from the prosecutor's office. It must be that you disagree as a policy matter on the issue of restitution, compared to my read of the judiciary's position on it. Is that fair?
So I'm going to interpret your question a little bit, and please feel free to correct me. But when you say that they say the restitution system is flawed, I know that they were saying that the chances of victims full recovery is very low. And again, we point out that it's zero if the court never orders in the first place. But that said, we think the judiciary underestimates the benefits of having restitution, a victim receiving restitution over and above financial reimbursement. The emotional, psychological, just the mental taxes on these victims. And again, some of them, maybe they can't even pay $100 unexpected expense or $1,000 unexpected expense, whatever it is, but now they're forced to do so somehow. Maybe they borrowed from friends or from the bank, I don't know. And frankly, sometimes they probably don't know either how they're going to do that. But the benefits of the restitution to the victims go far beyond financial reimbursement. And then I think also the judiciary's testimony focused on federal restitution, and perhaps I'm not as familiar with the federal system, but I think the state system and certainly what the legislature has tried to pass and implement surpasses what the federal system does in terms of trying to actually collect that restitution for the victims.
Okay.
And if I'm off point, then please, I'm happy to.
No, I guess, and these questions are focused on the testimony of the judiciary, the comments that you made in your testimony, the prosecutor's office made, seem to focus more on the benefits of the imposition of restitution on the offender. And at least the comments here, referring to prior statutes that the legislature adopted. And we're sort of focused on the rehabilitative aspects of the imposition of restitution on offenders. And I asked the first question because there's been a lot of reform nationally and then in the state as it relates to the juvenile justice system. And I'm just wondering if there's any quantitative or qualitative data to support that position, because there's been a lot of work done there. I'm wondering if the way the system is facilitated by the judiciary now, the juvenile system is facilitated, is it working or not? Do you have some sort of data to support the fact that this change is necessary?
And again, we will try to get stats on how many of these cases in which restitution is requested actually get the restitution ordered. Offhand, I think you're asking if there's any studies.
For example, we know that at the detention center, that's now Kawailoa. What we know is that we've dramatically reduced the number of juveniles in detention, and the data shows us that that's had a very positive effect on the juvenile justice system. So, is there some sort of national correlating function, as it relates to the imposition? Because I'm going to ask the judiciary the same question in a second, but I'm just wondering if there's something to justify this aside from the testimony that you submitted, which is relying on the prior policy statements of the legislature.
Well, I think that the victim advocates community and perhaps some CVCC or other victim advocates could speak to this better, but the victim advocate community feels very strongly that restitution plays a big part in making victims whole. Again, not just financially.
Yeah, I understand the victim side of it. I'm talking about the offender side.
On whether
because in your testimony, part of what you're saying in your testimony is that restitution is a benefit for the offender.
Yes.
It's definitely a benefit for the victim. I'm not going to dispute that, and I agree.
Okay.
But on the offender side, your testimony relates to.
And I'm sorry, it's not I'm sorry to interrupt you. I think I get the gist of your question now, but more. So, and sorry, this is not a study per se, but anecdotally, there are a number of juvenile cases in which it's very clear the law violators, the kids, they take great pride in paying it back. Once they get a part-time job, they like being able to pay it back, knowing that they are making somebody whole that they wronged. It makes them feel responsible. It makes them feel grown up. They're taking responsibility and accountable for what they did. And that's also part of the process that they learned ideally through the juvenile justice system, which they might not have understood before or internalized before. And there's a number of cases that we can point to in that it's very clear. That
But it's
it means
mostly
something to
anecdotal.
them.
Okay. Yeah, I'll defer, but I do have a question for judiciary.
Go ahead.
Okay, so for the judiciary,
Vice Chair.
okay, yeah, thank you. I'm wondering what your response is to this, because I see the two pieces of testimony by you and then this dialogue. I'm wondering why we need this bill. Can you acknowledge that there's an issue here? Because there obviously is one, or this wouldn't be in the prosecutor's package. So why do we need to get involved in this? Why can't the judges work? Why can't you guys just work this out?
Thank you, Vice Chair, for the question. I think that one thing which the judiciary's testimony and the prosecutor's office bill and testimony agree on is a clarification in 571-48, because there's a section that says currently the family court can impose community service or restitution. And oftentimes the family court is faced with a decision because of an appellate court decision, which reads it in a way that you can do one or the other and you can't do both. And so the family court sometimes is in a position where it has to determine, well, which is going to be the most beneficial and rehabilitative for the youth? Is it going to be imposing an order of restitution, which the youth may be unable to pay realistically based on some of the examples that have been laid out in the public defender's testimony, which are, I think, fair to say.
I mean, the prosecutor just said that even if restitution is imposed, there still are outlets for the offender to facilitate restitution without actually having to pay.
There is one program that's currently open only for youth who are.
So why do we need this bill? If that's the case, then why do we need this bill?
I think as long as the family court is able to retain the flexibility to have youth earn restitution money payments through the use of community service. For example, the family court could order restitution and then allow the minor to work it off, so to speak, and then get the credit from, you know, our accountability program, for example. That would.
So what I'm respectfully suggesting here is that it must not be working for us to have this, for us to be having this dialogue, and that the solution does not necessarily require legislation.
That's a fair point, Chair Keohokolo, and we would be willing to work with the prosecuting attorney and any other stakeholders as recommended by the public defender, Ms. Forrester.
Okay. Okay. So Kim, go ahead.
I just want to follow up. But currently it's still going to be to the discretion of the judge, and that's the problem. If the judges have a clear sense of that they just don't want to do restitution. And it seems like from what we've seen in measures where the judges are supposed to impose I forgot what that surcharge was on that, where they weren't imposing the surcharge to this fund that helps. What was that bill we had? But they clearly weren't even asking for that surcharge. So they just seem to be adverse to putting these fees or doing these kinds of restitution. So how do we remedy that if it's not through some kind of a mandatory measure?
Thank you, Senator Kim, for the question. I think one thing which this bill would accomplish is remove the ambiguity and make it clear that the family court can impose both restitution and community service. That would allow for the family court to issue a dispositional order that would impose community service on the youth, which would help them work and be rehabilitated that way to show them consequences of their law violation. And on top of that, order the restitution. And with regards to the prosecutor's office comment that the family court is able to make ability to pay determinations, that doesn't necessarily impact the total amount that we can order, but rather, as the prosecuting attorney's office indicated, the amount of monthly payments. It still results oftentimes that, a youth will reach the age of majority because of the monthly payments they were able to make. They still have a restitution balance, and we continue to see them on our restitution calendar well into their adulthood. So I agree that it's an issue. It's an issue that has to be looked at to see how we can, fine tune this and improve the system for the benefit of both the young adults and youth who we have coming through the family court, as well as for victims of crime and the community at large.
Okay, thank you.
Okay, members, any other questions? If not, I do have one for Judge Park. You have a suggested amendment to subsection 14 of the relevant statute there. When the court terminates jurisdiction, any outstanding restitution orders, including any orders made against parents of an adjudicated child, should be converted to an independent order of judgment, and a certified copy should be given to the victim to allow the victim to seek enforcement in proceedings provided by law for judgments. So I think you just described, so even right now, the situation is that if you still have if the judge gave the kid a restitution order and they still have a balance on it when they turn 18, you still have jurisdiction over them to drag them back into family court over and over again until they pay off the restitution.
That is correct, Chair Rhodes. So
Okay.
if you have a restitution balance, that's correct.
So this amendment basically says you'll still have the balance. It can be reduced to a judgment, and then the victim can try to collect it like you do any civil debt. But they're not coming back to family court anymore.
Correct. It would be sort of equivalent to in the adult criminal system when restitution is in a freestanding order of restitution, kind of similar to that. So we wouldn't have to have that young adult now continuously coming back to court. If they miss their court date, then there would be a bench warrant issued for them and they would get arrested on that.
Okay.
So we wouldn't have to have court hearings. Thank you, Chair Rhodes.
Thank you very much. If there are no other questions, thank you, testifiers, for being here. And we'll move on to the final bill on the agenda, which is HB 1469, creates an affirmative defense for anyone charged with unauthorized control of a propelled vehicle where the defendant purchased the vehicle in good faith and believe themselves to be the owner of the vehicle. First up on 1469 is William Bento for the Office of Public Defender. Good morning again, Mr. Komogami.
Yeah, I'm sorry. I'm going to stand in for William Bento. Alan Komogomi from the Public Defender's Office. Good morning, Chair, Vice Chair, and members of the committee. We're going to basically stand on a written testimony, but I just wanted to point out the problem we see with this bill is it shifts the burden to the defendant in a case where the person actually believed they bought the vehicle in good faith and had authorization to drive the car. The question is, in a case where someone buys a used car in Craigslist, let's say, and pays cash, the question is, if that car turns up to be stolen and that person was actually tricked into buying the stolen vehicle, how do they go about, proving by a preponderance of the evidence that they were duped? As it stands now, the burden is on the prosecution to prove each and every element of the crime beyond a reasonable doubt. And in a trial, that person could testify and tell their story, and then the jury would have to decide whether or not there's enough evidence. If this bill were to pass, the prosecution would now be able to attack the buyer's story and say, they didn't prove it. They didn't provide proof. And how do you prove that you were duped on Craigslist 3 or 4 months ago? I doubt that person who tricked you is gonna come to court and admit their wrongdoing, and there's not gonna be any paperwork. And I think this just eliminates one of the fundamental principles of our criminal justice system and due process. And so for those reasons, we oppose this bill. Thank you.
Okay, thank you. Next up is Trisha Nakamatsu for the Department of Prosecuting Attorney. And she's in support. Next, we have Jared Hiramoto for the Honolulu Police Department, also in support. That's all the testifiers we have on 1469. Members, questions? I have a question for public defender. So isn't this, there's already a list of affirmative defenses in this statute, right?
Yes.
Okay.
This would add us another affirmative defense.
Okay. In terms of the the logistics of it, are you, if one of your clients is accused of a crime like this that has affirmative defenses, are you required to tell the prosecutor that you're going to be using one of those affirmative defenses before the trial?
Yeah, we'd be required to disclose, what our defenses are, but I'm not certain we'd have to specifically disclose, whether or not they believe they were authorized to drive the vehicle or had permission, but.
So I guess I'm a little confused. And so you do or you don't have to tell the prosecutor what defense or what affirmative defenses you're going to use. Not that you have to get into the details necessarily, but I'm going to use this affirmative defense. I'm going to use this one. Do you have to do that?
Yeah, I'm not certain we're actually required to.
Practices that it happens though.
I think in most situations, it usually tends to play out before trial. We talk about the case. We get pretrial rulings. I think in most practical, for most practical purposes, it does get disclosed. I'm not certain we're required to though.
Oh, no, I'm just curious about what actually happens as opposed to, there's a lot of things that happen that aren't required.
Right. So I'm not.
You don't know. All right, that's fine. Thank you. Members, any other questions? All right, if not, thank you for being here, Mr. Kumagome, and
thank you.
We'll go ahead. I don't know. Members, the only one that I think there might be enough controversy on to discuss it privately is 1459. I was planning to shift it back to being voluntary on the part of the judge, a may instead of shall for the judge, but I think there's some other stuff in there that's worth keeping. So if you guys would like to discuss that privately, we can, but otherwise that.
Can we just discuss it
We
openly?
can just discuss it right now if you like it. So let me tell you what I was thinking of doing. We'll change it back from shall to may. Amendment which requires any restitution order to be converted to an order that the victim may collect when the family court's jurisdiction ends. So when a kid turns 18, and then make it effective upon approval. But the advantage of that is that then you don't have to, an adult doesn't have to get dragged back into family court over and over again. And if they miss an appointment, a bench warrant's issued and all that kind of stuff. This would just be like as I think they described it as like enforcing a civil debt.
What about the recommendation that we allow for the judge to do both?
That would be left in there so that right now the way they're interpreting it is that you have to do one or the other. You can't do both.
Right.
So that one of the amendments in here would be you can do
so
either or and. Yeah.
That one, both the judiciary and the prosecutor, they were coming from different angles, but they agreed that. Separating that so that there was a distinction.
Right, I think there was agreement between prosecutors and the judges on that. Yeah.
Is there anything we could put in the committee report to be concerned that these are issues that the judiciary and the judges should be looking at?
We can say we think that it appears that so few of these kids are given any kind of restitution that we wonder whether the judges are taking this seriously, something along those lines.
Something like that.
Okay, because it's not clear to me, well, it's not clear at the adult level either that they do it all the time when they're supposed to.
Because what was that one bill we had on that?
Crime victims compensation.
Right, the judges don't even make people pay for that. So.
Yeah, it's an issue.
Yeah. Okay, I can live with that for now.
Everybody okay with that? Okay. Other than that, I think most of this is pretty straightforward. So we'll go ahead and back to the top of the agenda for HB 124. This is
the last one.
I was just going to say, I was sort of a technical amendment. Instead of saying in good faith, we take that out and just say the purchaser reasonably believed they were the owner. So it would say you purchased, it'd still be the affirmative defense, which there's a whole list of affirmative defenses in that statute. So I don't think that's really much of an issue. they purchase a vehicle and reasonably believe that they were the owner of the vehicle, and they would have to demonstrate that as an affirmative defense, which by the preponderance of the evidence is the usual standard, which is lower than beyond any reasonable doubt. Okay. Okay, back to the top of the agenda, HB 124. This requires the chief elections officer to develop and distribute a voter information guide for all candidates running for state office, including Office of Hawaiian Affairs. Recommendation here is to so we'll amend the date to take effect for the 2024 election. We'll have the candidates submit their own 150-word statement for inclusion in the voter guide, but based on a template or criteria that the Office of Election creates. So there'll be sort of standard questions that they'll need to answer in 150 words. We will need to answer in 150 words, and include federal offices as well as state. And we'll take out the appropriation since it's not going to go into effect until 2024. Office of Elections can make the request for whatever they want to do, assuming it passes at that point. And then I'll also require that the statements be translated into Hawaiian in addition to the other languages that are required under federal law.
We're not going to put our language in there. Is that one of the things that
this is sort of the what would you call it, the information, voter information guide light. It gives the Office of Elections a lot more flexibility, and if they can convince us to give them enough money to do the full-on mail it to everybody, then great, but then they wouldn't necessarily have to, and they could do the trimmed down version if that's all we've got the money for that year.
Okay.
So there's no guarantee that any of these are going to pass, of course, but
Right.
that's, I figured keeping one in play that's a little more flexible might not really think.
Okay.
No sunset, Chair? You're just kicking out the effective date and then permanent?
This is Leslie's, right? Oh, no, that's Brent. Were we going to sunset too? Was it just the? You can change, okay, that's what, yes, it is sunsetted. But no, I wasn't planning to.
But you're doing 2024 election.
Yeah, it's sunsets
2024.
Okay, so we'll sunset it after the 2024 election. Yeah,
Okay.
so we'll just try it for one election, see how it goes. Okay.
2025 and 26.
Okay, okay. All right, any other questions? If not, Vice Chair.
Members voting on HB 124 HD1, the recommendation is to pass with amendments. Chair Rhodes.
Aye.
Vice Chair goes aye. Senator Ocasio.
Aye.
Senator Gabbard.
Aye.
Senator Kim.
Aye.
Senator Lee.
Aye.
Senator Favela.
Aye.
Chair, recommendation adopted.
Thank you. Next up is HB 1539. This prohibits posting of judges and other court staff's personal information on the internet with the intent to intimidate or threaten. Recommendation is to go ahead and pass it forward. We'll take out the definition of the judiciary, which seems unnecessary, and the current one that's in there seems inaccurate as well. We'll change the phone numbers to unpublished phone numbers so that if a judge posts their phone number, that's up to them. Include credit card information or credit card number or credit card information to the definition of personal information. There's several reports that are due before regular sessions, and we'll make those due 40 days before the regular session instead of 20. And then we'll make it effective upon approval. Any questions or concerns?
Can we have something on the committee part to just note that the judiciary as a separate branch have the ability to do task forces on their own?
The task force, yeah, we can say that, sure. They can do the task force on their own.
It just bothers me
I
that.
think there's some advantage to pulling in other people who are
Yes.
not from the judiciary.
But they still have that ability.
They could, but
What
yeah.
bothers me is that these entities who always want to be separate, then wait for us to do stuff when they can do it on their own, and they make excuses, well, the legislature didn't pass it, that's why we didn't do it. And they come in and they support it, well, then they can do it,
Yeah.
so.
No, I
anyway,
hear you.
Thank you.
Oh, yes, we can put in some committee reports that
Okay.
committee report on that effect.
Mhm.
Any other questions or concerns? If not, Vice Chair.
Members voting on HB 1539 HD2, the recommendation is to pass with amendments. Knowing that all members of the committee are present, are there any reservations?
Reservation.
So noted for Senator Favela. Any opposition? Seeing none, chair recommendation adopted.
Thank you, members. Next up is HB 1828. This is the Tax Board of Review reorganization. Recommendation is to go ahead and pass it with some amendments. We'll fill in the purpose. Basically, we'll reinstate the 3 full-time equivalent board member positions and 2 new full-time equivalent staff positions, as well as the appropriation in section 7 of $518,452. And then the actual take effect upon its approval, provided that section 7, which is the appropriation, shall take effect on July 1, 2022. And section 1, composition of the board, shall take effect on January 1, 2023. Questions or concerns? If not, Sir Keokolole.
Members, HB 1828 HD3 passing with amendments. Are there any reservations or no votes?
Resolution.
So noted. Recommendation adopted.
Thank you, members. Next up is HB 1841. This increases the rate of compensation and maximum allowable amount per case for court order counsel and guardians ad litem. Recommendation here is to just go ahead and put back in the suggested rates, the statutory rates, so $120 an hour for in-court work by an attorney, $90 an hour for out-of-court work by an attorney, $75 an hour for work by a non-attorney such as a GAL, and put back in the appropriation of $2.3 million.
July 1.
Yeah, I was looking at this other. Yeah, that's it. Questions or concerns? If not, Vice Chair.
Members voting on HB 1841 HD2 passing with amendments. Are there any reservations?
Resolutions.
Reservations for Senator Favela. Any no votes? Recommendation adopted.
Thank you, members. Next up is HB 2365. This creates an electronic citation program under the Judiciary and establishes an electronic citation surcharge. Similar to what we did before when we looked at the Senate version of this bill, I'd like to amend it to eliminate the surcharge. I don't understand, and the special fund. I don't understand why something that's supposed to save us money is going to cost people who are getting the tickets more. And we'll still authorize a statewide electronic citation system. Leave the blank. We'll put in a blank general fund appropriation for setting up the system in the judiciary and grants and aid for the counties, but we'll leave those amounts blank. And then we'll have committee language saying, questioning why instituting a system that is expected to save government money is going to cost violators more. And that's it. Questions or concerns?
You cannot take the money out of the fine already, but the fee.
Well, I think, yeah, my recollection is that all goes to the general fund. So we are. You could. It would be like you'd have to set up another special fund, I think, which generally is frowned on. So.
Okay.
Okay. Seeing other questions, go ahead, sir.
Members, HB 2365 passing with amendments. Are there any reservations?
Reservations.
Reservations for Senators Kim and Favela. Any no votes?
Ocasio.
Oh, I'm sorry.
You can go ahead and add me one.
All right. So we have reservations for Senators Ocasio, Kim, and Favela. Any no votes? Chair recommendation adopted.
Thank you. Next up is HB 2421. This establishes a 3-year women's court pilot program within the Judiciary's First Circuit. Recommendation here is to go ahead and put the money amounts back in the positions. So it's $695,236 for fiscal 2023. And then several positions, a social worker 5, 4 social worker 4s, 1 circuit court clerk 2, and 1 judicial clerk, that's what it's called. And then we'll make the report due 40 days before the session instead of 20. Questions or concerns? If not, Vice Chair.
Members, HB 2421 HD1 passing with amendments. Are there any reservations? Any no votes?
Okay, thank you. Next up is HB 1427. Clarifies that candidates are not required to file a preliminary general report, a general election report, if they are either unsuccessful or are elected to office in the primary. Recommendation here is to pass. It's housekeeping, pass unamended. Questions or concerns? No, Vice Chair.
Passing unamended. Are there any reservations or no votes? Recommendation adopted.
Thank you, members. Next up is HB 1456, amends the offense of theft in the second degree to include theft of an electric gun. We'll just put a good date on it, August 1st, 2022 for the effective date. That's the only amendment. Questions or concerns? If not, Vice Chair.
Members, HB 1456 HD1 passing with amendments. Are there any reservations?
Reservation.
Any no votes?
No.
Okay, I have reservations for Senator Favela, no vote for Senator Ocasio. All other members vote aye. Recommendation adopted.
Okay, next up is HB 1459. This is the one that we spent most of our time on today. Requires victim restitution in certain juvenile cases. The recommendation here is to pass with amendments. We'll change back the shall to may, so judges would not be required to institute restitution, but we'll put on the committee report that we're concerned that judges may be using their discretion a little too much, and that there is anecdotal evidence, at least, that the victim is, the perpetrator, whatever you call them, the child offender is, there is some benefit to them of having to at least pay for part of the damage they do. So we'll put some committee language in on that account. And we'll accept the judiciary's amendment, which requires any restitution order to be converted to an order that the victim may collect when the family court's jurisdiction ends, i.e. when the person turns 18. And that way they won't have to go back into court if they haven't paid the whole thing already. And we'll go ahead and make it effective on approval. Questions or concerns? If not, Vice Chair.
Members, HB 1459 HD1 passing with amendments. Are there any members with reservations?
Reservation.
Reservation.
I have reservations for Senators Ocasio and Favela. Any no votes? Recommendation adopted.
Thank you. Next up is HB 1469. This creates an affirmative defense for anyone charged with unauthorized control of a propelled vehicle, where the defendant purchased the vehicle in good faith and believing himself to be the actual owner. Recommendation here is to strike out the good faith requirement, which was kind of vague. Instead, say purchased the vehicle and reasonably believed that he was the owner of the vehicle, or he, she. I'm not sure exactly how we'll phrase it. And but it's still an affirmative defense. Questions or concerns? Vice Chair.
Members, HB 1469 HD1 passing with amendments. Are there any reservations?
Reservation.
Reservation.
Reservations for Senators Ocasio and Favela. Any opposition? Seeing none, recommendation adopted.
Thank you very much, members. We do have a joint with GEO this afternoon. Do you know what room that's in? Sorry. Oh, right here, 016 at 3 p.m.
I might not be here because I have my hearings.
Okay. Thank you very much for being here, everyone, and all the testifiers were adjourned.